Uttarakhand has become the first Indian state to implement the Uniform Civil Code or the UCC. But what does this mean for personal laws, and is UCC really required in India? Let's break it down. Starting with what is Uniform Civil Code. So Uniform Civil Code is a proposal for a law in India which would replace all the personal laws based on the religions. As of now, each religion has its own set of laws which govern the personal matters of people following that religion. With UCC, a common set of laws would be brought in that would apply to all citizens regardless of their religion. The UCC would govern personal matters like marriage, divorce, inheritance, adoption, succession, etc. On January 27, 2025, the Uttarakhand Uniform Civil Code Bill 2024 came into force. It applies to all the residents of Uttarakhand, including those living outside the state. To begin with, there is no change in the ceremonies of marriage. Marriages will be held as per the ceremonies of each religion and culture. Registration remains mandatory just like before. Coming to the topic of bigamy. Now, bigamy has been banned for all persons of any religion under UCC. The usual assumption is that this targets Muslims. But guess what? According to the government data of 2019-2021, Christians had the highest rate of polygamy, that is 2.1%, followed by Muslims at 1.9%, and not much behind are Hindus and Buddhists with 1.3%. So even where bigamy was already illegal, it has been practiced. Therefore, the provision is likely to affect men across religion if the enforcement is done right this time. Coming to the prohibited degrees of marriage, especially marriages among cousins. Contrary to popular belief, cross-cousin marriages are permitted in almost all religions and not just in Islam. For example, cross-cousin marriages are accepted among South Indian Hindu castes. According to the government data, 10% Hindus, 11.9% Christians, and 14.5% Buddhists marry among their blood relatives. Since this is so prevalent across religions, under UCC, marriages among blood relatives is allowed if the customs or usages permit the same. Therefore, UCC will have no impact on this as well. UCC is often seen as uniform solution to all vices and discriminations in marriages under different cultures. However, it is rebutted with the fact that we already have Special Marriage Act 1954. It is a law that can be opted by any person who wants to get married under a uniform law without taking away the individual autonomy and religious freedom. It is also believed that UCC will give adoption rights to Christians, Parsis, Muslims, and Jews. However, any Indian citizen can already adopt a child under the Juvenile Justice Act of 2015 and under the Guardians and Ward Act of 1890. Therefore, even on this issue of adoption, we already have a uniform law and citizens have freedom to choose. Supreme Court has time and again ruled against discriminatory practices and laws in the matter of adoption. Like in the case of Geetha Hariharan versus RBI, it was held that the mother can also be considered a natural guardian of her child, which is otherwise not recognized under the Hindu law. Now coming to another hot topic of divorce law under different religions. It is believed that UCC will take away patriarchal practices. However, by way of amendments and judicial decisions, this has already been done. Like the concept of mutual divorce was introduced in Hindu law in 1976 by way of amendment, and the practice of instant triple talaq, which has no place in Quran but was sparingly practiced, has already been rendered unconstitutional in Shaira Bano versus Union of India. Further, any person who gets married under Special Marriage Act can get divorced under the same act. Therefore, each citizen has a right to choose whether or not personal law would apply to their personal matters. Furthermore, in such cases, the law of inheritance are also governed by the Uniform Law of Indian Succession Act 1925. Meanwhile, Supreme Court has held several inheritance laws unconstitutional, like in case of Mary KP versus State of Kerala, the Supreme Court ruled in favor of equal inheritance rights for Christian women. Amendments like Hindu Succession Amendment Act of 2005 gave right to daughters to inherit property which was earlier not allowed under Hindu personal laws. In terms of maintenance, the Supreme Court has already held that under Section 125 of the CRPC, all women, regardless of religion, can take maintenance. So the law here is also already uniform. Therefore, the question arises, do we already have a uniform civil code? Now, Article 44 of the Indian Constitution states that states shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Civil code means more than just personal laws. Civil Procedure Code is the main civil law in the country, which is uniform as far as practicable. There are certain amendments to it which each state has made. In a country like India, where diversity is an asset, uniformity beyond all circumstances cannot be a practical dream. While general public believes that issue of UCC is related to Muslims, it is not true. The tribal practices of matriarchal societies in the south, Daya Bhaga traditions within Hindus, and Christians, Jews, and Parsi cultures will also be affected. In order to remove discrimination, vices, and biases across personal laws, bringing in laws which are neutral and leaving the choice to individuals is the only democratic way forward. While Supreme Court remains the guardian of our fundamental rights, rejecting all practices which are not in line with our constitution. Existence of child marriages, dowry system, polygamy shows that iron hand for uniformity cannot actually do away with discriminations in the society. Let us know your thoughts in the comments. That's all for this one. See you in the next video.